Professorate, faculty members of the CSIBER, faculty members of University of Avunia, my colleagues from UTM, dear students, a very warm namaste. So I'm Viraj Fulena, and today I'm going to talk about a very pressing phenomenon called miscarriage of justice. So why have I chosen this topic? Because in the changing world, this injustice is really touching the mankind. Can you imagine we have someone who might be innocent in prison and someone who is guilty walking away freely? The repercussion it can really have on the person and the family members as well. I've myself met a few victims of miscarriage of justice. Of course, our system is not ready to accept that they are victims of miscarriage of justice because unfortunately in Mauritius, we are not ready to accept collateral damage. Okay, so I'm going to speak about that in a moment. But can you imagine the state of mind of those people? Well, some of them went to prison some 20 years back, and after 20 years, they have probably not been freed by the court, but they have received the prerogative of mercy from the president. In fact, talking about a very famous case in Mauritius called the L'Amical case. Miscarriage of justice, I was very passionate about since I started doing my bachelor degree some 20 years back, and it was one of the topics which I wrote my first dissertation on with regards to miscarriage of justice. But what has really happened 20 years ago and now? Nothing. We've had minor changes in the law, but still the big work has to be done. Our system is still the same. There are still innocent people behind the bars, and it is really very sad and alarming, I would say. So my first impression when I met those people who came out of jail some 20 years back after being graced by the president was like, sir, I've lost everything. I didn't see my wife go. My children now are mostly adolescent, nearly about to get married. When I went to prison, they were only about 3 years old. So I haven't seen my father go or my mother go. So, you know, they have lost everything. We are trying to compensate those victims with money. But can money really buy those injustice that those people have been through? Okay, so I don't think money can ever buy freedom. Okay, so I'm going to start my presentation with regards to that. So the phenomenon of miscarriage of justice, there is a very famous English scholar named Sir William Blackstone. He was very eminent. He was also a jurist. And he said that it is better that 10 guilty persons escape than one innocent person suffer. Okay, so everyone in our criminal justice system has the presumption of innocence on them. So we are presumed to be innocent until proven guilty by a court of law. So what is that presumption of innocence? Okay, so whenever we are going to court, we are assumed to be innocent. The prosecution must prove their case beyond reasonable doubt. If there is the slight doubt that someone might be innocent, the case falls. Okay? So presumption of innocence is what we call during the prosecution, during the trial, the prosecution must demonstrate through evidence presented that the guilt of the accused is established to a moral certainty. So despite having such a principle of beyond reasonable doubt or presumption of innocence, it is alarming and disconcerting to acknowledge that innocent individuals can still find themselves ensnared in the clutches of wrongful conviction. Okay, so I'm going to let you read. For those, many of us might be, those terms might be new to them, so I've tried to summarize it in simple words. So the concept of beyond reasonable doubt is a fundamental principle in criminal law. This principle asserts that before a person can be convicted of a criminal offense, the evidence presented by the prosecution must be so strong and convincing that there is no reasonable doubt in the mind of a reasonable person that the accused committed the crime. You will see in law the concept of reasonable person. You will always find that everywhere. Who is a reasonable person? They are a person like me and you. Okay, so they are most lay people. This is why when you are called to be a member of a jury, okay, you don't need to have any knowledge of the law, because you might be biased in your approach. Okay, so now we are going to move on to have a look at the gist of our topic today, miscarriage of justice. So miscarriage of justice or wrongful conviction is when the justice system, which is supposed to ensure fairness, ironically results in injustice. In simple terms, it is a situation where a person is wrongly convicted or punished for a crime they did not commit. So nowadays, not nowadays, some 10 years ago, this miscarriage of justice before 2001 was something quite, well, no case could be overturned if there were fresh and compelling evidence, okay, to prove that the case was wrongly decided. It did not exist. But in 2011, the Supreme Court of England established guidelines to determine whether a miscarriage of justice has occurred. So they define a miscarriage of justice as a situation where new evidence or newly discovered facts demonstrate that the evidence used at trial against a defendant is so weakened that no conviction could reasonably be based on it. So this definition emphasized the critical importance of reliable evidence in ensuring fair outcomes within the justice system. So I'm going to put you a little case. You know, law is about case law. Okay, so I'm going to put you a case for you to better understand, okay, what is fresh and compelling evidence. So imagine a person named John was convicted of robbery based on eyewitness testimony and circumstantial evidence. You see, eyewitness testimony, a simple person coming and saying, I saw this person stealing, you will get done for that. Whether the person is credible or not, we don't know. Okay, however, years later, during an appeal, new DNA evidence emerges showing that another individual, not John, committed the crime. So this DNA evidence conclusively proves that John was not present at the scene of the robbery. So in that scenario, the new DNA evidence constitute newly discovered facts, fresh and compelling evidence. So that undermines the original evidence used to convict John. So that DNA evidence is so significant that it completely discredits the case against John, make it impossible to uphold his conviction. Okay? So now I'm going to take the case of Mauritius. This is what my research was about. What's the situation in Mauritius? What was it before and how is it now? So you will see that in Mauritius until 2013, where individuals were found guilty by trial courts, they had limited avenues for challenging their conviction, even when presented with compelling fresh evidence of innocence. Okay, so this is quite alarming. Can you imagine before 2013, if you have DNA proving that the person is innocent, even that the person would not be exonerated. Even the DNA clearly proves that the person is totally innocent. Okay, so the legal system in Mauritius emphasizes finality, which appeals primarily focusing on the safety of the conviction rather than examining the innocent claim. So there exists no precedent in Mauritius whereby a person has been exonerated following fresh evidence demonstrating innocence after a conviction. So it is indeed very sad and alarming. So it's not only in Mauritius. There is no doubt that the criminal justice system worldwide, okay, donc we have our fair share of mistake. In fact, we have to acknowledge the problem. You know, in Mauritius, we are very much reluctant to deal with collateral damage. So we tend, okay, to the society at large would demand for the truth, but we are not in a position, especially the judge or the magistrate, they won't say, you know, I have erred. The ego is there, okay? They won't accept the collateral damage. So when we look at this, it makes me think of a very famous novelist and journalist called Émile Zola, who stated, if you shut up truth and bury it underground, it will but grow and gather to itself such explosive power that the day it bursts through, it will blow up everything on its way. Okay, so this is a saying that is very much related to miscarriage of justice, because the day a person who has been wrongly convicted is out, then the repercussion will be really big. So fortunately, we did not get to that point in Mauritius where it really burst up, okay, but there was a report which I myself worked on in 2015, I think, some 9 years back, the wrongfully convicted report, which was written by a very eminent lawyer, Mr. Ramavalaiden in Mauritius, and a panelist of lawyers. I was still studying at that moment, but I formed part of that report. So this report triggered, okay, some changes. It was for the first time that we had things moving in the correct direction, okay? But after the report, especially based on that Lamikal case. So I'm going to explain to you quickly what happened in that famous Lamikal case. There was a football match in Mauritius where there were supporters from both teams that went to attend this match. After the match, of course, the losing side, they were really frustrated. Okay, so they went and it was claimed that they set fire to a casino. And so this made a lot of noise because there were a lot of people who were killed in that incident. A pregnant woman was killed as well. So it was really tragic. But you know, the sad thing is that those people, they were sent to prison only based on eye testimonies. And afterwards, we found out that those people who were the eyewitnesses at that time, they didn't like those people. You know, when I don't like someone, I just say, I saw him putting on the fire. Okay, so it was like that those people were seriously put behind bars. So this report tried to exonerate those 4 detainees, which myself I went to meet in prison. So they relate each and every moment that they were there protesting, but they never set the fire. Because, you know, after the match, everyone gathered showing their, you know, disapproval of the referee's decision, but no one set fire. Because scientifically it was impossible for them to set fire because the distance they were, they stood from where the fire occurred, it was rather impossible for them to send, you know, cocktails and put the fire. There was a lot of other testimonies from the actual people who did it in Mauritius. They were called the Squadron of Death, l'Escadron de la Mort. They came afterwards and say, we are already in jail for life, so free those people, they are innocent. We did it. But still, their testimony had no power in Mauritius. This is how sad it is. So this wrongfully convicted report, okay, donc what happened after the publication, it was still not possible for them to have any avenues to claim miscarriage of justice. Even the report was out, they couldn't secure, you know, their innocence. That was very sad. The only avenues that they had was to seek prerogative of mercy from the president, okay, which has been granted some 20 years after They were convicted in 1999 and they were granted mercy in 2019, some 20 years after. Okay? So when this report was released, there was a slight change. It was for the first time in Mauritius that the DPP decided to apply for review on the grounds of fresh and compelling evidence. It was the first time that the DPP said, if ever there were fresh and compelling evidence, okay, the court must be satisfied that there is fresh and compelling evidence. So what is fresh evidence? It is defined as evidence which was not adduced at the trial of the offense and could not, with the exercise of reasonable diligence, have been adduced at the trial. Okay? So compelling evidence means evidence which is reliable, substantial, and highly probative in the context of the issues in dispute. So this passing of the amendment created mixed feelings among various sectors, because some thought it was probably a big change happening. The wind of change is finally here. But to some, especially those 4 detainees of the Lamictal change, they were still quite in doubt whether they are going to succeed or not. In fact, they made an application under Section 4A of the Protection of Human Rights Act to the Human Rights Division, and the inquiry lasted 15 months to try to prove that there was fresh and compelling evidence. There was a commission that was set up which lasted 15 months. And after 15 months, the findings were published on 24th of June 2015, and the division was not satisfied that there was existing fresh and compelling evidence in that case, and therefore it did not refer the conviction to the Supreme Court for a review. So they are back to square one. Even there has been a change in the law in 2019, they are still stuck in prison because the commission has not accepted the fact that there is fresh and compelling evidence. So this clearly shows the reluctance on behalf of the authority to acknowledge the problem and deal with collateral damage. So until now, we are in 2024, nothing has happened. The detainees of the Lamictal were sent to, even went to the Privy Council. This is only the good thing that happened. The Supreme Court after that gave them leave to attend the Privy Council, but still, they didn't receive any grace. The only good thing that happened to them was the president in 2019 graced them, and they were out. So after 20 years, they were able to meet their family. I went to meet them, and most of them, they didn't know. You know the funny thing they told me? It wasn't funny at all. For me, it appeared quite surprising. I was in the car with them, and they saw the development happening in Mauritius. They were asking, how am I going to lift up they wanted to put a CD on. They say, CD in cars, we didn't see that. They remember the old cassette player. They didn't know that they could pull up their windows up and down. They were looking for this thing, you know. So they were completely cut off with change. Can you imagine 20 years of their life gone? Some of them, their children didn't want to accept them as their father, because since they were convicted, they have been ashamed to call that guy their father. So they refuse to acknowledge that he's going to stay in the same house as them. Some, their wives got married again. So they've lost everything. Okay, donc we saw that this doesn't happen only in Mauritius. It happens in other countries as well, including India, Singapore, Australia. So we haven't really faced a lot of public attention for such cases, but it still is alarming that innocent people are behind the bars and criminals are walking free. So what has been done so far to make sure that this problem of MOG is rightly tackled? There has been the advent of DNA testing. So the use of DNA testing has helped prevent wrongful conviction that could lead to imprisonment, life sentences, or even death penalty. In Mauritius, everyone involved in the criminal system should work together to minimize the risk of miscarriage of justice. Even in England, okay, the former Prime Minister Tony Blair apology to the wrongfully convicted Guildford 4 was a significant move in addressing wrongful conviction. In one of his statements, he said to the victims, "I'm very sorry indeed that this should have happened." Can you imagine? A simple sorry won't change things. Okay, so a quick summary of what happened. So the Guildford 4 case and the Birmingham 6 were flagrant cases of miscarriage of justice in England. Okay, so Guildford 4, they were wrongly convicted in 75 for the IRA bombings in England. They were sentenced to life based on coerced confession. And those convictions were, of course, overturned in 1989, and similarly in the Birmingham cases as well. So this part, I wanted to talk a bit about India. It was not part of my research, but since we are in India, so I wanted to see, to present to you what's the feeling. So I have quoted Vasu Agrawal, a journalist. Okay, so he thinks that in India the system is there as well. Okay, so I'm going to quote a little bit quickly what he said. So he said that the emblem of justice denotes that law is blind in itself. Law, though, is of utmost importance and utility for society to ensure well-being of mankind, it appears to us it has come under the grip of hardcore, powerful people who actually control the law per se. Can you imagine? We have a clear separation of powers in both India and Mauritius, and those separation of powers have the interference of external people, powerful people. So those self-acclaimed godmen or conmen escape the consequence of trespassing the law very easily, and thus it appears as if the law is just enforceable against the less powerful section of the society. Miscarriage of justice is not just confined to the financial status of people. It has other several dimensions, such as gender and political status. He used the case of Jasleen Kaur and Sarabjit Singh as one of the most highlighted benchmarks, as Sarabjit Singh, the accused, was harshly tried by media, and how his entire life got messed up just because of false accusation by a girl. He also quoted the famous case, the Nirbhaya rape case, where in that case he spoke about the victim's family who got justice after 7 years of crime committed when the court ordered death penalty for all the convicts. However, this highlights that there exists a number of loopholes in the judicial system, and not all the rape cases got the support and sympathy as the Nirbhaya case. Had it not received so much media attention, probably it would have gone unnoticed. So according to him, miscarriage of justice does not always occur through the verdicts of the courts, but can also result from the influence of the legislature and the executive pillars of the government. Okay, so now I'm going to focus a little bit on my research question, okay, on miscarriage of justice. So this is the final part of my speech today, and we are going to look at what are the root causes of miscarriage of justice, how to address and combat miscarriage of justice, what are the consequences of a failing criminal justice system, and suggestion for improvement in Mauritius and beyond. So I'm going to be quite quick on that because I know you might all be hungry at this time. Okay, so I'm going to simplify what are the root causes of miscarriage of justice. So miscarriage of justice happen due to several problems in the legal system. Mistakes or wrongdoing during investigation, police making errors or hiding evidence can lead to wrongful arrests. Wrong eyewitness testimony and false confession, okay, can happen as well. Police in Mauritius, I didn't write it here, police brutality are there as well. Try to force people to give I met a lawyer at court the other day. He told me that, there was a guy who had a criminal charge against him. Every time he goes to court, the case is postponed. So he's been to court 3 or 4 times, the case is postponed. Either the lawyers are not free, the magistrate is not free. So the prosecutor told him, just plead guilty. You will pay a fine of 2,000 rupees and you're going to get done. So he said, for 2,000 rupees, I'm going to walk away free. There won't be any hassle in my life. So let me just accept that I'm guilty, even though he wasn't guilty. So just to walk away from the system. So he paid his 2,000 rupees, and this was on his moral certificate as well. So he accepted to pay the 2,000 because this has drained him going to court all the time, taking permission from his employer. So just to show you that miscarriage of justice can happen at different levels. Poor legal representation, where lawyers are inexperienced, they give wrong advice to their client, could be a root cause as well. Systemic bias, discrimination, in Mauritius, when you see someone from a specific community, so you tend to say, you try to judge him before he actually appears in court because of his social background and where he comes from. So this is discrimination, flagrant discrimination. So we also have a very important aspect in miscarriage of justice is tunnel vision. Police are too busy focusing on only one aspect, one suspect. They are neglecting the other aspect that might exonerate the victim. They are focused on one person. He's the one. Okay, so this is called the tunnel vision. Focusing, like you put blinkers, you are focused only on one person, one aspect. Okay, so you tend to neglect the other people. Secondly, how has this issue been addressed and combated? So we have proposed a lot of reform proposal. This includes giving good training to police officers, trying to equip them with body cameras, because we don't know until they are arrested and taken to court what has really happened. Okay, so advance in forensic science have also played a very important role. Okay, I mentioned about the DNA testing, etc. And around the world, we had the establishment of organizations like the Innocence Project and review commissions that has been instrumental in investigating claims of wrongful conviction. Okay, so third part, consequences of a failing system. A failing criminal justice system leads to wrongful conviction. The public will actually lose trust in the system. Okay, innocent individual may be wrongly convicted, undermining faith in the system, fairness, and deterring cooperation with law enforcement. This can deepen social divides, particularly among marginalized communities, and contribute to increased crime. That guy who who was arrested just because he's part of a particular member of the society, his father was a criminal, so he as well might be a criminal. This has put a social stigma on him. So he's not going to get any job. He has this on his certificate of morality. What result has he got apart from going to commit another crime and stealing to get his life? Okay, just because he is from a marginalized community, he has already been blamed beforehand. Okay, so this is very, very sad, and this is a great cause of social divide. Okay, another very important consequence of a failing system is overcrowded prisons. There is no space in our prisons to cater for so many people. Okay, some of them might be innocent, we don't know. Can you imagine some people, because of the backlog of cases in Mauritius, they are waiting for 2-3 years to go for their first trial? So they are away from their family. They have not been convicted yet. The presumption of innocence is on them. But just because our system has a backlog of cases, they are in jail for a couple of years, waiting for their first trial. So no work. If they were the breadwinner of the family, how is the family going to survive? We don't know. So this is a very deep consequence of a failing justice system. Finally, the last part of my talk will be geared towards what are the suggestions, what are the improvements that have been made. Okay, so in Mauritius, we have legislative and non-legislative measures. Okay. What are legislative measures? We have to change the law in order to better address the system. Okay, so legislative improvements include the introduction of the Police and Criminal Evidence Act, although in England this act came out in 1984 and is still not yet in Mauritius. So they're already disregarding this act in England, saying it's already outdated, but in Mauritius, okay, they are trying to at least have this act, because from the very time of an arrest, okay, it has some set procedures on how to deal with the detainee so that we can avoid MOGs happening. Abolishing the provisional charge system. Can you imagine? I don't like someone, I just say that this guy has harassed me, or girls would say that this guy has sexually harassed me. So there's a provisional charge against that person. Although the person might prove his case afterwards in the eyes of the society, trial by press, he has already lost all credibility. So this is another flagrant part of MOG, miscarriage of justice too. We need to be able to abolish the system of provisional charge. Well, in Mauritius, what happens? The guy came after 20 years in prison. What about compensation? Nothing. He doesn't have a job. When he's going to apply for a job, he's been 20 years in jail. Who is going to give him a job? In the UK, we have what we call the Victims Code. So the family are remunerated. Okay, if you have proved to have been wrongly convicted. We need to have public funding for those people who have lost everything in their life. Okay, so a compensation structure needs to be in place. Non-legislative improvements includes a creation of a school for magistrate, what we call in French, École de la Magistrature, to offer adequate training to magistrate before they give a submission. Can you imagine in Mauritius how you become a magistrate? If you are a lawyer, you've worked for 2 years only in the what we call the social, the SLO, okay, which we call the parquet in Mauritius, the state law office. You are eligible to become a magistrate. 2 years. And that 2 years working in the SLO, don't know if you've been to court, what job have you been doing. So how do you know that this person is fit to give judgment? So we need to have, just like in France, a school for magistrate to cater for those people, to teach them how to give verdicts. 2 years as a lawyer does not make you a magistrate and play with lives of people. Okay? So we need to have also lawyers from the DPP's office, the Director of Public Prosecution, or State Law Office in every police station, to make sure that since that person is arrested until he's released, the right procedure has been respected. There has been no instance of miscarriage of justice. Police officers need to be offered proper training. In Mauritius, we have only the police training school that provides training to police officers, but I don't think that is enough. We need to have foreign people with expertise from other countries to come and teach our local police officer. So I'm not going to be too long, all right? So I'm going to end up with this beautiful saying. In the pursuit of justice, we must never forget that human face of those impacted by its miscarriage. Our commitment to fairness, accountability, and integrity must remain unwavering. For every wrongful conviction represents not only a failure of the system, but a profound injustice inflicted upon innocent lives. Thank you very much. So I'm ready to take any questions. Yes.
Yes.
I know there might be a lot of questions, so go on.
Hello.
Hello, sir.
It was a very interesting presentation.
and I'm really very happy because you have touched a very sensitive subject again. I just wanted to know, like in India, we have different law commissions coming up, and they give guidelines for improvements in this area. So we had our 277th Law Commission report, where public prosecution is now identified, and a lot of suggestions are given. So I wanted to know what system is there in Mauritius, like, you know. So like you're talking more about systemic reforms rather than individual or judgmental things. So I wanted to know more about how Mauritius works in this area.
Well, like I mentioned, very good question. Okay, so I think India moves very fast. We need to copy from them, because just like CSIBER today, whatever something is done, the next minute is on the internet. So we go very fast here. But in Mauritius, since 2013, unfortunately, like I mentioned, nothing has happened. The only thing that has happened is that DPP is ready to accept fresh and compelling evidence. That's it. That is the only change, positive change that has happened. But until now, no one has been exonerated based on fresh and compelling evidence. How sad it is, you have a system in place, but it's not been used correctly. We have a lot of improvements that are suggested, but you know, they are only words. Nothing has really been put in place. We are waiting for the PACE, the Police and Evidence Act, to come into practice. This has been suggested in Parliament some couple of years back, but still now, nothing has happened. Okay, so the system is very low, very slow. Okay, so we hope that those improvements would come quickly, because we cannot play with lives of innocent people. That's it. Thank you.
Yes.
Any other questions?
Yeah. Actually, the continuation to earlier question itself. I was just looking about the legal system of your country, and just like India and Mauritius have a colonial common history, and you are also colonized by French as well as British. So your legal system is more influenced by French acts, as well as now recently, as you are mentioning continuously, that about British law is more, influencing legal system in your country. So my question is about like, is there any effort from the political leaders of Mauritius to decolonize the legal system in your country, so that the miscarriage of justice, whatever is highlighted, can be addressed thoroughly?
Very good question. Thank you very much. So Mauritius, we have a hybrid system of law based on our colonial masters, being the French and the English. Okay, so we have a very rich system. But in Mauritius, we have taken the best from the French and the English law to come into a third stream of law named as the Mauritian legal system. So we have our unique system of law, and we do not blindly follow what's in England or in France. We have our own legal system, our own system of courts. We might use French or English law only, to make references, only for persuasive purposes, okay? But we are not blindly following those laws. Also, there is the will of political leaders, but the problem is that whenever there is a political issue, if one government comes up with a change, the other governments, out of ego, would vote against. This is not my project, so why should I vote for it? This is how it is. So political will is there, but I don't know how it's going when is it going to have, when are we going to have a consensus between both the opposition and the party in power? That's it.
Are they having any decolonizing the legal system?
Yes, we are
already decolonized.
Our constitution, I think, was pretty much the same time as India in 1968. We are thinking of revamping our constitution, okay? Because you know it was written in 1968. We are now in 2024. There are a lot of things with the advent of technology, climate change. So many things are happening, okay? But the constitution still dates ages back. Said there is a great will on behalf of political leaders to review our constitution. This is on the table since a couple of years, and I'm sure that very soon this is a good thing that both the opposition and the government, they are speaking the same language for the first time, to have our constitution revamped after so many years. So let's hope that this is going to happen and it will reflect on the needs of our society nowadays. Thank you.